today, the High Court that's sitting in Pretoria set to hear arguments by lawyers of former President Jacob Zuma to appeal that decision to send him back to jail. They arguing that the judge in that matter, that's Judge Matojane, erred in failing to acknowledge that there's no prison that's able to cater to Jacob Zuma's medical needs. In court papers, his lawyers also argue that Zuma is terminally ill and sending him back to prison is tantamount to a death sentence. The Correctional Services Department, for its part, is also appealing that decision and is convinced that another court will make a different conclusion. Afriforum, in the backdrop, opposing both appeals in court. Our legal analyst this morning, once again, is Benedict Phiri, who joins us via our video link. And Benedict, I hope you can hear us now. Part of the point I was trying to make earlier on is whether or not we believe that the arguments that are being made, at least by the Correctional Services Department, speak to the core of what's at this case. In part, what they're saying is that Jacob Zuma can't go back to jail because him getting a direct sentence doesn't mean he's not eligible for medical parole. Do you think that will stand?
I think that will not stand at all, actually. And I like how you've categorized it as saying, does it go to the core of the case? And we should just think about that, really. The core of the case is whether Arthur Fraser, at the time, firstly had the legal power to make the decision to put the former president on medical parole, and secondly, whether he could actually override the recommendation of the Medical Parole Advisory Board. And that's really the crux of the issue. And, you know, it's very clear from the reading of the Act, and I think Judge Matojane has done a really good job at explaining that Arthur Fraser didn't have that power. And in fact, the power sits with the Medical Parole Advisory Board. And this is why Afriforum is in the background, because you'll recall the crux of their case was a declaratory order. They were seeking the court just to say, please declare that the Medical Parole Advisory Board is the right body to grant medical parole. So that's why they're actually opposing this leave to appeal. But certainly, I don't think that any of the arguments that are being made by the Correctional Services Department and the former president actually go to the crux of what we're actually dealing with here.
Yeah, the reality, of course, is that we could be in this situation for a long time. In other words, this appeal process could take quite a while when you consider what can happen after the stage if things don't go Jacob Zuma's way. I can't help but wonder whether or not, how will we deal with the situation where, given how long it takes, there is a moment that unfolds where the former president legitimately can't go to jail because of his ill health and his age. What would happen in that context?
Well, then a fresh application for medical parole has to be made. You know, ill health on its own or age and ill health working together are not necessarily a reason to put a person on medical parole. The reasons are that somebody should literally be on his deathbed. He should be terminally ill or should be incapacitated to such an extent that he cannot look after himself. So we haven't heard that from the former president at this particular point in time. He hasn't said that in any of his affidavits. None of the medical professionals have actually said that. Yes, they're concerned about his health, but no one has actually said that he fits into this pigeonhole, which fits the Act squarely. So if we ever did get to that point in time with the passage of time, then there is space, for him to actually make an application if he's sent back to jail at that point in time, right? Because that will still be available to him to make that application if he actually goes back to jail.
Yeah. That ruling from Judge Matojane gave out a cost order to both Jacob Zuma and Arthur Fraser. We spent a lot of time speaking about the former. What kind of consequence management do you reckon needs to happen for the latter, for Arthur Fraser?
So I think, for Arthur Fraser, he's probably gotten away with this as an individual, but certainly for the Correctional Services Department, I think it's very clear now that the rules around medical parole are tightening, and we're not going to have in the future similar situations like this if we take the tone of, Judge Matojane's judgment. I think fortunately for him, a personal cost order wasn't sought against him in this particular aspect. So I think for him, he's sort of shielded in a way, but certainly the Correctional Services Department has to tighten up around the process for the granting and issuing of medical parole going forward.
Yeah, speaking about the tone of that judgment from Matojane, I mean, part of what that judgment was trying to actually communicate is that the message from the initial judgment from the Constitutional Court mustn't be lost. In other words, this idea that nobody is above the law needs to be sacrosanct and communicated unequivocally. Let's balance that according to what apparently Jacob Zuma's legal team has also said, which is something along the lines of them saying that Jacob Zuma has special rights, and those rights are in some respects captured by his ability to receive specialized medical treatment from the National Defense Force. That argument with the message of the judgment, how do you think that will play out?
Again, Judge Matojane very clear that an issue here is firstly the question of equality before the law. The fact that you're a former president should not have ever been considered by Arthur Fraser. Medical parole is medical parole, and the only consideration is whether you're terminally ill or incapacitated. There's nothing there that I believe actually takes away from Jacob Zuma's rights. It doesn't fall within the ambit of the consideration of medical parole. And, the former president's lawyers did not argue that the medical parole provisions must be extended to take into account the former president and his special needs, etc. They did not argue that. The only argument was that Arthur Fraser was correct to make that decision, which they failed on. So there is no scope to bring that argument at this point in time, and in fact doesn't sit within the framework of the granting of medical parole. So I think that's really quite a misplaced argument in the context of where we are in this matter.
Benedict Phiri, our legal analyst this morning. Always great to chat to you, sir. Thanks very much indeed for making time.